Please be seated. All right, everyone. Before we begin again today, I want to remind everyone that the court has entered an order on decorum for this proceeding, similar to the one that we had last week. So there shall be no outbursts, no photography of the juvenile at this time, and no videography of the juvenile either. There are orders that we need to enter for preservation of the juvenile's rights and victim rights of the family as well. So please make sure you follow through with those orders. At this time, I would ask, it looks like the juvenile delinquent facility is still muted, so I'd ask the facility to please unmute. Attorney Cohen, can you hear us?
Yes, Your Honor. Good afternoon.
Attorney Newell, would you be able to call this matter and give the appearances, please? I would ask the attorneys to please refer to the juvenile by initials for this proceeding. Go ahead.
Yes, Your Honor. It's C, middle initial T, last name P-B, case number 2022 CF 265. Wade Newell appears on behalf of the state. Also present on behalf of the state is Sheila Yonk. The juvenile and his attorney, Michael Cohen, appear from JDC in Eau Claire via video.
Thank you. All right, this is a continuation of the hearing from last week. The public defenders appearing with the juvenile last week had sought a continuance for the appointment of new counsel, and we have counsel Michael Cohen appearing with the juvenile from Eau Claire. Attorney Cohen, did you want to address anything in this matter today regarding those time limits that had been previously waived by the previous attorneys in this matter, and whether you wanted to address any hearings going forward?
First, Judge, we are not going to at this time address bond. Secondly, we are not withdrawing any waiver of time limits. I spoke with Mr. Newell very briefly late last week, I believe, and we had discussed what we were going to do today. He advised that at that time he was still waiting for any information beyond the probable cause statement. He advised that he would be willing to give some time for those materials to be provided to his office, to provide them to me so that I could review them with my client to determine whether there would be a need for a preliminary examination or whether there would be a waiver of the same. I'm in agreement with that. I've discussed it with my client. He understands that he will remain here at the detention facility while this case is pending, at least unless there's some circumstances regarding bond, which we will not be addressing now. So we would ask the court to give us, I think that given that we're not rushing for speedy dispositions on prelims and things like that, I'd ask for probably 45 days for Mr. Newell to get the information and to get it to me, and for us to then review it together and then to come back to court.
All right, does that make sense for us to come back within around 45 days, Attorney Newell?
Yes, Your Honor.
Right, then at this time I am going to go off the record, and we will compare schedules so we can find a date that works in the future. We are off the record. All right.
Judge, just on that point, Judge, what I was thinking is that if 45 to 60 days works with the court and Mr. Newell thinks he can get me information, I would be prepared to set that hearing as a preliminary examination or a waiver thereof, depending on where we are, just so you're aware. I'm not looking to drag this out unnecessarily, but I want to be able to at least have a meaningful conversation with Mr. Newell. So with that in mind, and Mr. Newell's thoughts about when he's going to get the information and how fast he can get it to me, that might also help us with scheduling.
Your Honor, regarding that, I'm hoping to have at least a majority of the information by the end of next week. Been in consultation with the Chippewa Falls Police Department regarding that. Regarding the setting of the preliminary hearing, I'm fine with that, although if there is going to be a preliminary hearing, there's going to be the need, obviously, to subpoena witnesses and have people clear their schedule. So it may be better just to set it for status first and then for a set date where we would know whether a preliminary hearing was going to be held or not.
All right.
That's fine, Judge.
Okay. Well, if we want to go out 45 days, I have the entire day available on June 23rd and June 24th.
States available both those days, Your Honor.
If that's going to be a status, Your Honor, I would be available on the morning. I could do the morning of June 23rd. I could also do the morning of June 24th, whatever is. I have to be in court in Eau Claire at 11, and I'll be on the 23rd, and I'll be in Barron in the afternoon of the 23rd. So perhaps the morning of the 24th would be best.
Does 9:30 work?
On the 24th, it does for me, Your Honor.
9:30 on the 24th, yes, Your Honor.
Yeah, that should give you plenty of time to complete the hearing and get to your next hearing at 11, I think. Attorney Cohen, does that work?
My hearing's on the 23rd, Judge, so if it is on the 24th, I'll be fine. I guess my question, Judge, is if it's going to be a status, will the court have my client again here at the facility, or will he be transported?
I'm fine convening these hearings electronically by video, as long as both parties consent, which is the new law that we have earlier this year. As long as both parties consent to having these hearings conducted by video, I will honor that request.
And Your Honor, if
For purposes of,
sorry, my only suggestion would be that I don't even, since it's simply essentially a scheduling hearing, I think we could do that. We could have it during that time, but we wouldn't have to have it in open court. It's essentially just to set a new date.
Sure. That said, though, we do have our new Marcy's Law, which representatives of any complaining witness or victims may have input at that time as well, so we would have to make sure that they are properly noticed. All right. Attorney Cohen, anything that
I have
you
no
want?
objection, Your Honor. I have no objection to the next hearing on June 24th at 9:30 being done in the same fashion. I will be present with my client by video here at the detention facility.
Okay. Then at this time, we are back on the record. The court and the attorneys have coordinated their schedules and have set a hearing for June 24th of 2022 at 9:30 in the morning for a status conference after any evidence has come into the state's possession and for the defense to determine whether or not it may want to seek a preliminary examination or not. And so that way we can update the status in this matter at that time and then do further scheduling as well. I wanted to bring something up to the parties today. I've received numerous requests from press contacts in this matter, ex parte requests for release of the criminal complaint that was ordered to be held under seal by the clerk of courts, as well as search warrants that have been filed with the clerk of courts in this matter after they've been returned after being executed. And there's been requests from press contacts for those to be released. The court notes that our public records law has a presumption for complete public access to court, or not court documents, but public documents, which these are. They are held in the custody of the clerk of court's office, but they are under seal, and so they remain closed due to that order. And so I wanted to first ask the district attorney, since it was the party that requested to have these matters be held under seal, whether or not there are any objections with the court ordering that be released so that those contacts may have those documents.
You referring to just the search warrants, Your Honor, or the complaint as well?
To confirm on the complaint, the court ordered the entire complaint be sealed, but I believe, just to confirm, you had asked for just the victim key to be sealed at the last hearing, correct?
Correct.
Okay. Are there any objections to having the complaint released?
From the state's perspective, no, because the victim's information is not contained within the complaint.
Attorney Cohen, are there any objections or anything that you'd want to make for the record if the court were to offer or to grant the request in this matter for release of the complaint?
Are you only asking about the complaint, Your Honor, which my understanding is a 1.5-page document? It does not have any, let me just review it just a second, Judge, before I say that. The complaint that I have, Your Honor, in my possession is not one that has the name or the date of birth of my client removed. So to the extent that if there's one that's been filed that I'm not aware of that changes that and removes that identifying information, let me say it this way, Judge, at this time I object. I don't want this case tried in the media. I haven't seen any search warrants, the returns thereof, the evidence. I certainly don't want that information in the public arena before I get a chance to review it and address it. I don't know that there's a need for the media to have this information right this minute. There may be a time in due course where I remove that objection. Perhaps that could be raised at the time of the June 24th hearing. But I have little to no information about this case, and I certainly don't want to be finding out about it first from some media outlet from England or California or Texas or wherever. I don't know that there's a need to release it now.
Okay. Just to bring you up to speed, Attorney Cohen, at the previous hearing, I ordered that the complaint be held under seal, and that if it were to ever be released, that all names of any juveniles be redacted, except for the initials of the defendant. And so therefore, no names of any juveniles or dates of birth would be included as part of any release. But I note your objection. I am also offering the request to any representatives of any victims here today, if anyone wants to speak in that matter. All right.
We're just talking about the complaint right now.
Just the complaint right now. So, as noted, our legislature has enacted a policy which says that there is a presumption for complete public access. And so I am going to grant the request of the parties seeking the criminal complaint in this matter, and that complaint will be released to the public and to those parties who have requested it, subject to redaction by the court of the names of all juveniles or any witnesses who may be mentioned, as well as any addresses and the dates of birth of any parties. I would note to any party who has requested a copy of that document that the redaction will not be done today, and the document likely will not be available until sometime later tomorrow or Monday. So that way you can expect to receive documents at that time. So the next item then would be the warrants. Attorney Cohen, I'm assuming the same objection as you had made before. You have not seen those documents or the return of the evidence that was received from when those warrants were executed, correct?
I haven't seen anything other than the complaint that I mentioned, Judge.
All right. Any thoughts on that? As discussed, it was the state that sought to have those warrants held under seal, seeking to have the secrecy of those documents remain in place. Are there any items that you would like to make for the record on whether the court should release those documents, Attorney Newell?
Your Honor, I believe that the reasoning behind the sealing it to begin with is still present. My understanding is I don't think it's on all the sealed documents, but at least some of it noted that the investigation would probably be ongoing for at least 90 days. It asked for essentially 90 days by which to keep it sealed, at least 90 days to begin with. I know on two of the search warrants, well, all the search warrants, but two or three of them in particular, the reasoning for the sealing of it is because it has the victim's identifying information, and because it's a search warrant, it has a lot of identifying information regarding a lot of people in that, but more presumably the victim, juvenile victim, and the juvenile defendant. So I have concerns of that information going out, because now, and I understand the court's ruling, not the court's ruling, but the court's rules regarding not sealing documents, but we also, as the court already mentioned once today, we have Marcy's Law, which creates more of a constitutional privacy right for victims than we had before then, which is like in criminal complaints now, we don't list the victim's name, we just call them victim 1, victim 2, or just victim. I think that the victim in this matter, even though deceased, still has the right to have that information not publicly available. I'm not naive enough to think that they don't have it, because this case started out as a missing child case that then turned into a homicide case, so there's information that the media has, but none of that information that the media has is from the district attorney's office or the criminal filings in this matter. So I guess I would ask that due to the privacy concerns for the victim, unless someone raises that it's not a concern for the victim, that we keep that information private, and at least keep it private for the next 90 days while there is still an active investigation into the matter.
Thank you. Are there any representatives of any victim or victims' families or representatives that would like to speak in this matter? No, Your Honor. All right. Then, at this time, based on the requests of both parties, I will not grant the request to unseal the warrants in this matter until that investigation period lapses. We can address this again at the next hearing as well, so that way the parties have a chance to determine whether or not it was necessary for unsealing to occur at that time. Are there any other items to address today, Attorney Newell?
No, Your Honor.
Attorney Cohen, were there any other items you wanted to address for the record today?
No.
All right. Then at this time, I will see everyone back on June 24th at the time we scheduled, and bond will continue in this matter. We are adjourned.